Good afternoon, everybody, and welcome to our webinar focusing on Clery Handbook highlights for the new Clery Handbook that was released in the end of June. We are really happy that you could all join us today. I'm Alison Kiss, the Executive Director of the Cleary Center. I'm joined by my colleague, Abigail Boyer, who's going to take us through the bulk of the highlights that we have on the slides. We're also extremely thrilled to have Jim Moore from the Department of Education, the Clery Compliance team lead, join us as well to give us some insight on some of these changes. As we go into this, just a quick legal disclaimer. The Clery Center, we're serving as a training resource, so we are not providing legal advice during this, and we encourage you all to direct legal questions to your institutions or your counsel. We can't determine, so asking questions about compliance and whether or not you're in compliance is not something that we do, nor is it our job to do. The only people who could do that are the Clery Act Compliance team with Department of Ed upon a thorough review. I also want to state that, again, we're thrilled to have Jim from Department of Ed on this call. But certainly, if you ask a question about compliance or whether or not you are in compliance, it's not one that he could really admittedly. It's something that's determined case by case and through those evaluations. So just to be clear in going through this process. If you are having any trouble with sound or with volumes, you certainly can send a message to us and we can try to assist you with that, or call the tech support of GoToWebinar, which is our webinar host for this. Throughout the webinar, you can ask questions. You can enter them into the question or chat box. We will try our best to touch on some of the themes throughout this, but we have over 800 people on this webinar, so it will be difficult to respond to each individual question. We are going to make sure that we print out the questions at the end and share them with our hosts as well, so we can pick up on what some of those themes are as well. The Clery Center, our mission and values, basically we're working for safer campuses, and one of our key taglines or values is that we like to lead with mind and heart. So really thinking of compliance as the baseline or the floor, and thinking of what we can do or how we can do this to best care for our students. An overview of the Clery Act, as many of you are likely aware, since you're on this webinar, the Clery Act focuses a consumer protection law. It centers around an annual security report that includes policy statements, so key policy statements around reporting crimes, around offering assistance to students and employees. Those policy statements are basically summaries of complete policies, and then crime statistics that are collected in certain campus property. There's an ongoing disclosure requirement that's around timely warning and a public crime log, as well as emergency notification, which was added in 2008. And it is enforced by the Department of Education through the Clery Compliance team, so separate from Title IX and Office for Civil Rights. The handbook, just an overview. If you're new to the handbook, some of you are not and have been working in this since the first version in 2005 and then the updates in 2011. The 2016 is the newest version, and it reflects the interpretations and guidance of the regulations for Clery, and obviously the most recent changes through the Violence Against Women Act amendments to the Clery Act. It replaces previous versions of the handbook, so certainly there may be differences in the 2011 and 2016 handbook. You use the most recent version. It does not replace, obviously, the Clery Act, and it can be used by the department's program reviewers when they're evaluating compliance.
And we just wanted to highlight, we know we're assuming, certainly for those of you who are joining the webinar, if you're familiar with the handbook, we're assuming you have a general understanding of the Clery Act, but we also recognize that we're going to be covering a lot of different content over the next hour and a half that can be overwhelming. So the goal of this webinar is really to give you some action items, some areas to look to in the handbook. We always recommend you read the whole thing, but as you look at different questions that may have been coming up at your institution, there's a lot of great additional clarity and information from the Department of Education. So this webinar can really help be that resource to figure out, well, where are some of the key places that we need to look to, or some of the resources that I can share with other individuals on my campus.
So some of the key pieces in our agenda today. It is not possible to cover every change in the handbook. It's something that you should certainly read. The language is basically in very frank language. So it's a great way to kind of go through these areas and to kind of touch on key highlights in geography, in statistics, in the disclosures and policy statements around domestic violence, dating violence, and stalking, and then around the annual security report. I do want to take a moment now to see if, Jim, to pitch to you to see if you wanted to take a moment to introduce yourself in the event that some of our attendees are not necessarily aware of your role.
Sure. Thank you, Allison. Well, hello, everybody. My name is Jim Moore, and I'm with the U.S. Department of Education. I manage the Clery Act Compliance team, and we work with our policy staff at the department to produce the handbook. And we are happy to finally have the newest version of the handbook available to the community. And we know that it is going to take people a little bit of time to familiarize themselves with this new material, especially around the VAWA requirements. And we are happy that you have joined this call today in an effort to increase your understanding. Some of the feedback that we have received about the new handbook, most of it's quite good, but there have been a few questions, and we know that we may have to continue to clarify some of this information as time goes on, and we will endeavor to do that. People generally have reported to us that they seem to be getting more clarity out of this version of the handbook. I'm not so sure that is because of anything we have done at the department. I think it's because there's a growing sophistication among users of this material and professionals in this industry, and that schools are dedicating more time and resources to making sure that they're doing what they need to do to keep their campuses safe, number one, and number two, to make sure that they are in general compliance. As Allison said, I will try to contribute to this discussion. The ladies at the Cleary Center have been very good in offering me the opportunity to join today, and it's sometimes a little bit difficult here at the department to work out the logistics of those things, so I'm thankful to them for the opportunity to participate, and to all of you for taking the time to join today. And with that, I will hand it back.
Great. So we're going to start with geography, and the first topic is around the separate campuses. And so what we did there is you'll see references to the pages where this can be found, where what we're talking about can be found throughout the handbook. And so we are going to, and I jumped on the wrong slide, we're going to start specifically about geographies and how it's defined in the regulations, and kind of going through there. I think one of the first pieces are around institution associated or foundation, an institute-associated foundation, a holding company, alumni association, any kind of entity that may contribute a building. So I think hospitals came up, medical centers. And I don't know, Jim, if you could provide us with some feedback on this area or this change specific to, for example, an institution-associated foundation property.
Yeah, well, I think you summarized it very well. And the idea here was to, once and for all, we hope, clarify that when we talk about institutions, we're talking about the entire entity, right? So for many years, schools apparently, we found in our cases, were confused about the status of their hospitals, of some of their other facilities. Even in some cases, schools were unsure about how to treat their own bookstores, since they have licensed them out to perhaps someplace like Amazon or Barnes and Noble. On many campuses, alumni associations or booster clubs or other kinds of entities have buildings on campus, sometimes a very strong presence on the campus. And we wanted to make clear that all of those kinds of things are in. Now, that does not mean that everything that is branded with a school logo, for example, is necessarily in. I think we've also tried to clarify that certain investment properties, for example, or just where schools allow their name to be used by retail stores or commercial districts, there's many times when those things aren't in. But when you talk about the buildings and properties that are part of the school and its campuses, we have tried to clarify through this language that all of those things are in Clery geography.
I think that's helpful too, because that was always a frequently asked question that we were receiving. One of the questions that's coming in from a participant is for the guidance in this area, would that also extend when they're making that consideration? Should they be thinking using the same context when it comes to some of the properties that they might be looking that would be more likely to fall within non-campus?
Well, in a general sense, I would say that's the place to start. Start with wide expanse and then work in. And sometimes when you really get to the marginal cases, those are times when about the best thing that schools could do is consult with either the department or another trusted source to try to figure out where that line is. There is a line there, but it's not always a thick black line. And so I would say start with the idea of including until you can come up with a good reason to exclude it.
Right, that's helpful.
And to continue, as we move on to the next piece with reasonably contiguous and kind of a clearer definition there, or a more clarified definition, I think this also provides an opportunity for many of you who are listening in to go back and reevaluate or to get buy-in. If you don't already have buy-in from whomever on your campus is handling real estate or property, here's your opportunity. If you are unsure, you need to have those people at the table to really go through and determine what you're considering certain properties to be, and then documenting why you came to those considerations. And so one of the areas that is certainly an area to look at is when you're thinking about what's reasonably contiguous. In the past, there was no clear definition because it would vary from campus to campus. And I think that what we saw through this handbook is that this is all going to be on a case-by-case basis. But here looking, they're kind of adding this mile rule. And as I understand it, the mile is a mile within the campus, the on-campus area. There's no barriers or fences or anything kind of separating those pieces. It also was the understanding that it's an opportunity for a campus to reevaluate, for example, residence halls. Are there residence halls that they were considering non-campus that are maybe going to be on campus and are going to require you to look at the fire safety elements and thinking about what the purpose of the law is to keep students safe? And so really kind of evaluating those pieces. Jim, I know that a question that we've received quite a bit, and I know you've already been on the road talking about the handbook, is whether or not, or what's reasonably contiguous, the mile rule, kind of what some of the rationale behind that is, and how you can still make this on a case-by-case basis. So I didn't know if you would be willing to speak to that.
Yeah, I think some of the initial feedback that we have received is along the lines of concerns that maybe we have tried to have a general expansion of Clery geography. That is really not the goal of this rule. I have seen very few cases where there are schools that have actual residence halls within a mile of their campus core that they have carved out in some way. There are some limited cases where that's not true, but especially in urban campuses, it's not that uncommon to have a residence hall that is perhaps a mile or more away from the core. And what we're trying to do here is use civil engineering and other standards that are used when people develop shopping plazas and casinos and convention centers about what is a reasonable distance to expect a person to walk and still consider themselves to be within the same general vicinity. And that number is usually somewhere between a half mile and a mile. And a big reason that we had to go in this direction is not for the traditional campus, but for some of our for-profit schools that for a variety of reasons have gotten into the housing market. And a lot of times that's for enrollment management purposes, but very often you'll have a school that heretofore thought of their campus as the space that they occupy, say within a business park or a single building on a street. That's the campus and nothing else. Yet they have acquired, either by purchase or leasehold, some apartments in a building nearby to house certain students who attend their school. It doesn't make any sense from the public policy perspective to say that those students shouldn't be afforded the same information and protections as students who live in a dorm on a campus. And so we think that the fire rules were always intended to apply to that situation, but that the drafters weren't really thinking about these non-traditional schools. And that's where you get the idea of this 1 mile rule. It's not to be a general expansion of Clery geography, because we think that most schools were already including their housing that was within a reasonable distance from the core of the campus. But this was really to get at these other schools that may have housing units that would not have been thought of as dorms or student residences in the past.
And I think that's kind of an overarching takeaway, is that Clery geography hasn't changed, but what this does is provide you with additional context as you're making that evaluation. I know something that we frequently hear, or a question that we would always get at trainings is, well, then what is the area that we should consider to be reasonable? So for us, especially because we do get a lot of questions, and I know many of you are from very different institutions, we know that not every campus looks the same. So some of these areas of the handbook, what we appreciate about them is they really help you put this, put the regulations, put the statute into the context or the frame of your own institution, and give you questions to ask yourself as you're making that determination. So thank you for that additional clarification.
Abby, I think that is a very important point, and I know that you and the team there have seized on that right away, and we actually think that that's very important, and it was one of the intentions, because we have seen institutions consider properties as reasonably contiguous that are several miles from the campus, just out of an abundance of caution. Mostly because of concern about their students, but secondarily because they thought that at some point we might question what they have done. What this does in that sense is actually constrain Clery geography and better define it than it was before.
Right. So moving on to separate campuses, and this is an area where really you want to consider, and I'll stress again throughout the case-by-case basis, often you may see a campus that has a non-campus property where they're holding a class as part of a program on the main campus, but then eventually they start to realize that that non-campus property is easy to get to for example, working people, and they start to schedule more classes, and then they eventually have a certificate program running out of there, and they hire an administrator to come at certain times. So you really want to look at the organized program of study. So does the location offer courses in educational programs that can lead to some type of credential or degree or certificate? There doesn't have to be administrative personnel there at all times to qualify. It can certainly, we can think of research campuses in this area as well. And I don't know, Jim or Abby, if you have anything to add based on some of the interpretations or questions around this.
The only thing that I would point before I see if Jim has anything to add is some of the areas that we've pointed out here are some of the specific examples that might not apply to every campus. So you might not be an institution that has a research campus or an athletic campus, but some of the areas that were fleshed out in the handbook provide specific examples that many institutions may have been asking or considering. So even as we go through this webinar, a question that we had come in is, are you allowed to ask questions as we go along? Absolutely. We appreciate the folks that are doing that right now. We're working to incorporate the patterns or themes to the questions, as many as possible, into this webinar. We recognize that we're not going to be able to cover absolutely every question, so we're going to direct you to resources at the end of the webinar for further questions that you might have, or other webinar opportunities where you can engage with some of these areas. But Jim, I don't know if you have anything else that you'd want to acknowledge regarding the definition of organized program of study, which I know is something that we really appreciated seeing within the handbook, or any of the other examples that we have listed in this section.
Yeah, I hope that the information on an organized program of study is a little bit clearer to people. One of the things that I've been talking to groups about is that if you want to understand Clery, you have to understand a little bit about Title IV. And so in some ways, reaching out to your financial aid people on campus to have a general discussion about what some of these terms mean in the higher education and Title IV context can be helpful. Because if you don't understand some of the rules that apply to not only this area but others that we may touch on in this talk, you'll never really completely understand the context. One quick thing about separate campus is that I know that sometimes schools struggle with the idea, well, what is a separate campus and what is just a non-campus building? And it really does go to this idea of does the building or property have some kind of a brain center? Are there people like there that are directing activities? Does the place have its own budget? Or is it really just like a building that's available for classroom space? There are a lot of schools now that will jointly build classroom space in some strategic area to benefit from transportation patterns or workforce patterns or other things that might make the school or school competitive in an increasingly competitive higher education market space. A lot of those buildings are not campuses. Those are your true non-campus building. But if it is functioning as a school, then it's probably a separate campus. And you really need then to know what's happening there. So you as a Clery professional or a campus safety professional who has been tasked with this duty can't really determine in some cases what definition applies until you know what happens in the space. So again, this is the idea where schools having Clery compliance officers can come in handy, because there needs to be somebody who can move about the institution and get the information that's needed to make those kinds of determinations in the first place.
Right. And so a couple, I'm just going to go through the last three slides around geography. On-campus student housing, we're also including there something that's physically attached, if it's parking facilities or dining halls, if it's physically attached to the housing facility. As we move into non-campus buildings and properties, I'm really just going to highlight the top one, owned or controlled by a student organization if the organization is officially recognized or registered with your institution. So something to consider here is, and I know we had a question come in about Greek life. If you do have a fraternity or sorority that kind of takes hold of, let's say, an off-campus house, and they are renting the house for an extended period of time, and they put the letters up on the house, the landlord lets them do that. The university is acknowledging that this is the location of the property, then you really want to go back and reconsider that this may be a non-campus property, or it sounds like it would fall into it. Whereas if you have two members of the soccer team who live in an apartment off campus that's not owned or controlled by the campus, and they just call it the soccer house for the one semester they're living there, that certainly is not something that sounds like it would fall in that realm, just to give an off-the-cuff example. There was more clarity, and lastly, there was some more clarity around trips to off-campus locations, and this really built on the guidance that Ed sent in, I believe it was May of 2012, that really honed in on overnight trips. And so here you have it drilled down a little more, that kind of an overnight school-sponsored trip might not be counted, but repeated use of the same location through some kind of written agreement or contract, or even just an email or annual reservation is something that would count. You also want to look at short stay-away trips, and obviously you want to consider control there. So if the stay-away trip is through a sporting tournament and another institution is hosting and controls the property, then they might count it, but it likely would mean that you would not. So those are kind of really broad, high level. In the interest of time, we realize there could be a number of scenarios for these, but the guidance appears to be really clear. So again, we can't stress enough the need to document and on a case-by-case basis evaluate these relationships and where the folks on your campus are going.
Yeah, and speaking of scenarios, another thing that we wanted to point out is, one, the handbook goes into specific examples or case studies in certain areas that we aren't covering in the webinar, but are certainly helpful to reinforce a lot of the themes that we're talking about here. You also may have noticed that in the slides, we tried to incorporate a couple of cues for when you're reviewing them later. If you've not yet downloaded those slides, I know they were emailed to participants ahead of time, but a reminder that you can also download them from the handouts tab within your web pane. But within the slides themselves, you'll notice that certain content is bolded. And for us at the Cleary Center, that was areas, while it's all important, those are areas that we thought were most going to influence institutions or address some of the key questions that we've been hearing most often from colleges and universities. So that's the first thing to take a look at. The second piece is that you notice a couple of numbers listed after some of these key points. Those numbers is really your link to the source material within the Handbook for Campus Safety and Security Reporting. The way that the document is now broken down is by chapter and page number. So for example, on this slide where you see it says 225, that indicates chapter 2, page 25. So some of the questions that I'm seeing come in, we're answering as many as we can, but we do have over 800 participants. Some of those answers are clarified within the handbook, so this gives you a good guide as to where to go as a starting point, and certainly we'll make sure you have our contact information beyond the webinar. But before we move on to crime statistics, is there any other information, Jim, that you would want to kind of highlight or expand as we move away from geography?
Only this. I know that schools sometimes struggle with this idea of foreign travel and some of these short stay-away trips. I hope that the guidance that is in the handbook now gives more clarity about what is in and out. And what I would say is that we know that some of these attempts to get data, especially from certain foreign governments, is difficult. I normally would not say this to an outside group, but I and others are actually working to effect a change in this rule eventually. You have to do it for now, but we think there are some things that we could do, especially with foreign travel and some other short trips, that would be more useful to students and parents and less burdensome to schools, basically, essentially travel advisory information as opposed to these crime statistics that are not in any meaningful way differentiated from your non-campus buildings that are much closer to home, and in that way those statistics are not always of a lot of value. But just try to apply this guidance the best that you can and let us know if there are things that you think are still unclear.
Right. And I think we always like to drill it down to action items, or what can we take away from this. So other than certainly reading what's in the handbook, a lot of what Jim has kind of reinforced throughout is going back to the drawing board and looking at what properties do we own and control. That's our first starting point to figure out, okay, once we've determined what property we own or control, now let's figure out where and how it needs to be categorized. And just to reinforce that when we're talking about written agreement, especially for those of you on the line who may be attorneys, who might have a specific sense of what a written agreement entails, a written agreement doesn't have to mean that there's a formal contract, but there's information that's linking the institution to that geography in writing. So recognize that there might be some differences between how you perceive a written agreement versus what's considered for Clery. The question is, what do you own, what do you control?
So, Abby, if I could, just for 1 second, because again, this is an important point, and it's important for folks who are involved in compliance and at each institution represented here. One thing would be, you need to make sure that there's some kind of mechanism within your institution that you, whoever is responsible for Clery, who are probably the people on this call, that you know when your school acquires or sells a property. We continue to find many schools where the person who is somehow, or persons, committee, whatever, that is supposed to make sure that these rules are applied properly, don't even know what's in and out. Some schools are counting properties that they sold years ago. Other times, even police officials who are responsible for doing things like setting patrol zones or sector maps find out that they're not really patrolling the areas that they own or control, so they can't possibly be in compliance. That's simply unfair to those professionals, and a real problem for the institution and for the safety of your campus. And also, just to piggyback on Abby's point about written agreements, it might surprise you to know we have seen written agreements in one case on a napkin, in another case on a Post-it note. That's real. And in both of those cases, rather eccentric people wrote down that the school can use property they own for some purpose that they care about. In one case, there was a wealthy man who said, this building in town right near the campus can be used as the new geology department and for no other reason. And he did write that on a napkin. That's a writing, and it counts. So you would have to know that before you could even figure out just what buildings and properties are in and out of your geography.
And Jim, this may seem like an obvious question, but that would also point to whether or not the institution actually engages in that request. So say they're getting random letters from people saying, hey, you can use my apartment for a class, unless they're choosing to engage in that written agreement, they wouldn't be including that in their geography, correct?
No, that's true, and there have been cases like that. There's been people who have tried to bequeath properties to schools that schools don't want and will often give back to an estate, say a building that's just in terrible disrepair in a dangerous area or something like that. I mean, for it to be in an agreement, both sides have to want the property. And so most of the time, there are these extreme examples that come up, but usually there'll be a paper trail, at least of, for instance, emails or insurance contracts or some other kind of set of writings. The big issue is that the people who are responsible for making these determinations from a Clery's perspective just need to know that those negotiations and agreements have been made.
Right. And we'll try to move a little bit more rapidly through some of the rest of the content because we do want to make sure that we cover everything. But we know, even just based on some of the questions from the prior webinar that we did, a lot of the questions that we're getting to the Clery Center, geography was an area where a lot of people were asking additional questions in relation to the handbook. So we wanted to spend a little bit of extra time in that area. But we're going to move on to crime statistics. So again, a lot of the information in the handbook didn't necessarily change, but there is some specific clarification as to what you need to be considering and how you interpret and count specific offenses. So the four kind of buckets that we see these incidents being broken down into are criminal offenses, hate crime, VAWA offenses, and arrests and referrals for disciplinary action. So when we're talking about criminal offenses, those are the incidents of criminal homicide, which would be murder, non-negligent manslaughter, and manslaughter by negligence, sexual assault, which is broken down into rape, fondling, incest, and statutory rape, robbery, aggravated assault, burglary, motor vehicle theft, and arson. For hate crimes, we include any of the offenses that I just mentioned and any incidents of larceny, theft, simple assault, intimidation, or destruction, damage, vandalism of property that were motivated by bias. And the VAWA offenses are the offenses that were included within the most recent amendments to the Clery Act in 2013. So as we're going through these slides, some of the things that we're going to talk about, you're going to say, well, this doesn't feel new to me. And the reason that it doesn't feel new is we've received a lot of information, a lot of additional guidance in the form of the preamble that was given with the final regulations to the Clery Act that we received in 2014. So recognize that as you go through the handbook, some of the things might not be new or you might not be changing your practice because you've already taken these steps to align with, what we saw in the final regulations. What it does do, though, is it gives you additional context and things to consider in these areas. So for the VAWA offenses, that means we're looking at incidents of domestic violence, dating violence, and stalking. Although we know that sexual assault, we certainly saw changes within the Violence Against Women Act amendments to the Clery Act, and we'll talk about that, especially when we address Chapter 8. For VAWA offenses as its own separate bucket, we're looking at domestic violence, dating violence, and stalking. And then arrests and referrals for disciplinary action for drug law violations, liquor law violations, and weapons offenses. And so one of the areas that is a change in direction from institutions is looking at how the statistics are disclosed separately for each of the four separate categories. So prior to this handbook, there was more of an informal hierarchy, so to speak, when we were talking about arrests and referrals. What the change in structure does is it hopefully compartmentalizes how you're counting statistics in maybe a more digestible way as you're figuring out how to implement this on your campus. So if we're talking or if we're looking at the hierarchy rule, which is the rule that institutions use when more than one offense happens within the same occurrence, within the same time frame and distance, that will only be applied to criminal offenses. Arrests and referrals do not fall anywhere within that hierarchy, nor do hate crimes or VAWA offenses. Jim, do you have any additional kind of context or clarification that you wanted to give to that area?
Just real quickly, one of the things that we realized is that it was not clear to the community the liquor, drug, and weapons offense statistics were separate from the hierarchy of Part 1 offenses. And so that was one of the things we wanted to clarify carefully in the handbook, that these are 4 distinct buckets of statistics. And so that one particular transaction or occurrence of crime could constitute a countable offense in more than one. We also wanted to make clear that the hierarchy rule, how it worked for our purposes. One thing to always keep in mind is that the Clery Act, people say all the time that it's based on UCR. That's not really true. We do not use the UCR system. We borrow some of its definitions and have modified some of them for our purposes and use pieces of their program. We generally use the hierarchy rule, but we use it in a slightly different way than they do. For example, you know that under Clery, arson is an exception to the hierarchy. Well, under UCR, so is motor vehicle theft, for example, but we don't choose to do that. We now look at homicide as an exception to the hierarchy rule, to the extent that if you have a sexual assault that also resulted in a homicide crime, you would count it in both places. Now, what we also allow you to do is add caveats or clarifications to your annual security report or to your postings to the online cutting tool, so that you can make it known to people that even though a particular incident occurred in it, that it was one crime, that, or one offense, one incident, that in fact it had to be represented in the Clery statistics in various ways as a means of giving context about that incident. So we could imagine that we have a sexual assault that also results, unfortunately, in a criminal homicide that might also be a hate crime that could possibly be a VAWA offense as well. Right? And so that you might have the same crime represented on the stat sheet 4 times. We do not believe that that results in some kind of duplication. We think what it does is that it adds context. But folks that are doing the actual scoring of crimes have to understand what's in and what's out.
Yeah, absolutely. And I think that brings it back to a key point in that not every person on your campus, we're going to talk about campus security authorities in a moment, not every CSA might be an expert in the hierarchy rule with how it's applied for Clery. They might not be an expert in how all this information is counted, but you should have individuals on your campus who are. So the sharing of information is going to be really important. And there are also areas outside of the statistics where you're sharing information on an ongoing basis that is also providing context to your campus community as to what information is included in those statistics. So they have received prior information, or there are other areas in which they're receiving knowledge of crimes affecting the campus community outside of just these statistics for context. A couple of things that we highlighted, none of which are bolded, but certainly things to keep in mind. One, there was a small language change, negligent manslaughter to manslaughter by negligence. The definition didn't change, so we don't anticipate that that would affect institutions or how they approach negligent manslaughter, but just something to note. For sexual assault, again, this is something that we saw change within the final regulations, but this is the first time that it's incorporated into the handbook, is they're no longer broken down into forcible and non-forcible sex offenses, but rather the 4 categories of rape, fondling, incest, and statutory rape. And that was a result of the change in definition to rape that is far more inclusive than what institutions were using in the past. And just from Cleary Center perspective or experience, unfortunately, we were seeing institutions include incidents within their non-campus, or excuse me, within their non-forcible sex offenses that truly wouldn't fall as non-forcible. So I think the clarity around these four definitions and these four areas also helps institutions be a lot more clear as to what would constitute, for example, a rape or a fondling or incest or statutory rape. One of the questions that came in from a participant, which we'll address later as well, is that fondling should only be counted if it's the only sex offense. So the participant was saying, well, we might have incidents of rape, for example, in which fondling was an element. So the department did provide some good clarification around fondling only being counted if it was the only sex offense or the only aspect of sexual assault that's included within the statistics. And again, that is specific to your Clery geography as well. And then this last area is that although the definition of sexual assault includes a lack of consent, no determination as to whether the element is met is required for reporting within statistics. So it's an important element so that we don't have campus security authorities trying to evaluate whether or not consent occurred in order to be passing the information along. One of the things that we always go back to, and then I'll turn it over to Jim in case he has anything to highlight in this area, but one of the things that we always go back to is the statistics are really meant to reflect the crimes reported to the campus. It's not reflecting an outcome necessarily of the criminal justice process or the student conduct process, because everyone's decisions are different if and when they choose to make a report. So we want to think about those Clery statistics through the lens of reports on campus, not necessarily findings in other areas. But Jim, is there anything that you would kind of expand on for that area?
Well, I think that was an excellent explanation. The one thing that I want to raise for fondling in particular, and it applies to a couple other crimes, you have to be careful about applying some of these definitions. As you know, the definition for fondling in our regulation talks about a person who essentially inappropriately touches another for their own sexual gratification. Now, what that causes some schools to do, especially schools with people in leadership who have been prosecutors, for example, is to start thinking of this as a specific intent crime. It almost is never that. Sex crimes are almost always general intent crimes. So what you should not do is spend a lot of time trying to figure out, well, we don't know what the person's intent was. If a person inappropriately touches someone in one of the ways covered by the definition it's in many cases that we see, we have mostly young women who are inappropriately touched by people riding on bikes or skateboards who ride up to them, commit these crimes, and then ride off. And they say something lewd as they ride off, or they're laughing. They're never captured. The police are never going to have an opportunity to interrogate that person to assess what their intent was. This also happens in the area of burglaries. A lot of the burglaries we see in the campus context happen in a non-forcible way. You're never going to catch the person who illegally trespassed into somebody's room, took their money off of their shelf, and left. That doesn't mean that you don't count those offenses. It just means that if you were going to prosecute a person for those crimes, that you may need to have a better assessment, understanding, and documentation of why they did certain things. And that's the difference between crime classification and prosecution. We also continue to see institutions unfound cases, and I know Abby will mention unfounding, but they will unfound cases because, for instance, a prosecutor declines to take a case forward. That's never a reason to unfound a criminal report. And so you have to keep these things in mind and be somewhat mechanical about the process, or it will lead you to places that could cause problems for the school.
Yeah, and we are going to cover unfounding, but I think that's a perfect place to highlight that there's some really good additional context, a couple of pages that will be highlighted in just a moment in your slides, that really help you walk through better understanding what would be unfounded. We find that especially institutions that might not have sworn law enforcement are the ones that have the most questions around this. So even having the context of that a crime can only be unfounded by police is going to be relevant here, and we'll get to that in just a moment. We won't spend too much time on this because, again, we want to make sure that we're spending our most time on the areas that we know we've been hearing from you, we've been seeing from the questions are your kind of big focus areas. But what we will direct you to is to look to the pages that are highlighted on the screen related to aggravated assault and burglary. I think there's a lot of really great additional context, for example, talking about incidents in which something that started out as horseplay can turn into aggravated assault. Talking about the deciding factor for ag assaults, really looking at the evaluation of all the available information, looking at oftentimes that deciding factor is whether there was a weapon used or the extent of the injury. So for classification related to aggravated assault, there's some good context there. And then for burglary, we know we could spend an entire webinar on burglary just based on the types of questions that we get at the Clery Center and at trainings, and I'm sure the department gets on a regular basis. So I think some of the additional context that they provided can help to address some of those concerns, which often come up because the definition of burglary for Clery might be different than how you've considered burglary for your own state laws. So it's a good reminder that for these purposes, we're putting on our Clery hat, making sure that we're looking to Clery definitions when we're making this assessment as to what falls within our statistics and what doesn't. And there's also some good key information about some of those incidents that may be more confusing for institutions. For example, when there's unlawful entry without force, some good information about evaluating attempts and the different factors that you should consider in relation to burglary attempts, and some good additional scenarios that can provide good reasoning or good examples as you're looking into these factors yourself. For arson, one of the things that I think was really helpful to highlight was the fact that the department focused on the fact that it does not require, so when there's that evaluation as to whether there was an arson on campus, it doesn't require a finding from a fire official in order for the incident to be classified as arson. There does need to be a designated official on the campus that is the person that the institution goes to, or perhaps there might even be people with that background and knowledge that they go to make that determination. So again, as we're identifying our action item, a key question that I would ask at on an institution is, who are those individuals on our campus? Who are the institutional officials that would make the determination on our campus as to whether an incident was an arson? And then again, additional context and information regarding classifying them, especially for scenarios in which, say, for example, it's difficult for the institution to determine the point of origin. The department really clarified that if you can't define the origin, so say there's a fire that occurred in a privately owned house and an on-campus building, and we're not sure where that point of origin was, the institution would reflect that within their arson statistics for their on-campus building. But before we move on to some of the hierarchy rule exceptions, Jim, did you have anything that you wanted to highlight for those particular crime areas?
I think the reference to the arson clarification is important. We hope that it's clear in here now, as I mentioned earlier, that arson is an exception to the hierarchy rule. Some schools continue to struggle with that element of the law, even though that's an old standard part of the Clery Act. And then this clarification about determinations by fire officials. The reason that's in there is that many jurisdictions have a state or local law that say a burning is not an arson unless the state fire marshal says so, or something like that, right? Well, we'll have very serious fires on campus where they won't be reflected in the Clery statistics, and someone will say to us, well, the state fire marshal said he wasn't coming, ergo it's not an arson. You know, they only have 3 people for the whole state, and they don't come around here very often, so we didn't count it. Remember generally that any time you start your explanation of why you did or didn't do something under the Clery Act with one of 2 things. Either, well, you have to understand our state law requires X, or we have a policy as an institution that requires Y. That will often create a problem. Okay, so you really need to understand what the federal rule is here and then try your best to reconcile it with what your state or local laws require or what your institutional policies dictate.
Right, so we're going to move along to some of the hierarchy rule exceptions, which again, looking at the categories within those 4 buckets also helps to make these exceptions a little bit clear as institutions are organizing within their brains, so to speak, how they're counting and classifying these crimes. So one that should look very familiar is that if rape, fondling, incest, or statutory rape occurs in the same incident as murder, count both the sexual assault and the murder. It should be familiar not only because Jim said it earlier in this webinar, but also because that was information that we saw within the final regulations. And Jean Cleary's death, unfortunately, is an example of that, because we saw that's an example of an incident in which both a rape and a homicide occurred. And for the prior interpretation of that, it would have only been reflected as a homicide. So with this new exception to the hierarchy rule, it provides good context to the institution as to what happens for those particular incidents. As we mentioned, fondling recognizes an element of the other sexual assault, so only include a sexual assault as a fondling if it's the only sexual assault that occurs. And I want to reiterate here that for the purposes of Clery, anytime the phrase sexual assault is used, that's referencing those 4 crimes of rape, fondling, incest, or statutory rape. So you might hear those used interchangeably. They certainly mean the same thing for the context of Clery. We also have the hierarchy rule exception when it comes to hate crimes. So what we would point you to is a couple of additional definitions. One, we have a definition for gender identity that institutions can use when they're evaluating incidents of bias. So that's really useful because we know that that is an additional category that was added with the 2013 Violence Against Women Act amendments to the Clery Act. So certainly something to be taking into account and making sure that we have a good understanding as to what that means and what these biases might look like or mean in the context of an institution. This is also an area where within the handbook they have some examples. Unfortunately, I'm sure many of them may be based in experiences that institutions have had with hate crimes. So something to look at or consider if you're looking to better understand. And also look to who the experts are within your campus and within the community. So unfortunately, we know that these hate crimes are included within Clery because they are areas in which, unfortunately, members of our community might be impacted by a perpetrator's behavior, particularly as a result of their bias. So having an understanding of what these biases might look like, of all of these different identities and how the campus can best support them is going to be really critical, not only for Clery requirements, but also just to provide the best support that you possibly can to your community. We also highlighted the updated definitions for ethnicity and national origin. So prior to the changes to the law, you were including ethnicity and national origin as one category. They are now split out into 2, and the definitions are included within your slides for reference. So we won't spend our time reading those to you, but just additional context or things to consider as you are navigating these hate crimes and the reporting of hate crimes on your campus. We also have the additions within the Violence Against Women Act, so the VAWA offenses. So one of the points that Jim made earlier, which I think is so important, is looking to the fact that not all of our definitions are coming from uniform crime reporting. So again, going back to that context of, are we putting on our Clery hat? Do we have an understanding of what's required under Clery in terms of these definitions? Those of you who have already had the chance to read this within the handbook probably recognize, again, the information doesn't feel new to you. And the reason to that is that many of you probably have seen this in the preamble to the final regulations, in trainings that you've attended since the regulations were put into place. But a couple of the things that we highlighted are things that you likely read before, but to take into consideration, especially as you're counting the statistics for these areas. One good point that we saw in the preamble that we also saw in the handbook is the fact that the victim might use language other than dating. So we're not assuming that the person has to come forward and say, I was in a dating relationship with this person in order for it to fall within the dating category. So students might use language such as hooking up or many other phrases. I may have been out of college far too long to know all of the current trends, but chances are, as you're working with students within your community, you have a good understanding for your particular campus, because we know that sometimes that can also vary from campus to campus as to what is common. You have a good understanding as to what's implied when people are discussing their dating lives or the language that they use to do that. So recognize that they don't have to describe it in that way in order for it to fall under dating. Domestic violence should be more than just two people living together as roommates, and I'll open up space for Jim to provide some context on that, because we know that comes up quite a bit for institutions that have state laws, for example, where roommates would be included within their definition of domestic violence. And the Violence Against Women Act definition for domestic violence does point to state law as you are making these considerations. So, Jim, is there any additional kind of thoughts that you would want to add for, in addition to what's in the handbook, for that topic?
So, first of all, I think that was an excellent overview of what we set out as the requirement. But just to give you a little context and then perhaps a little relief, contextually, you are going to find, as I'm sure most of you already know, that as a consequence of what I euphemistically refer to as 21st century college sexual dynamics, you are going to have a hard time in some instances figuring out who's dating and who are actually domestic partners. There are regional and cultural differences here. I have had these issues arise in interviews I conduct with our own complainants or students that we interview during cases, and we'll ask them, well, were the two of you dating? And you'll hear, well, we see each other sometimes, or we've been talking. Or if you're really up on all of the current language, they'll say, well, we're Netflix and chill buddies. That's actually a thing, ladies and gentlemen. As far as who's a domestic partner today, you will have people who say, in response to your questions, I stay there sometimes. I keep some of my stuff at his place, right? So here's the thing. We want you to use your skills to try to assess what's going on here and then make the best effort you can to classify things correctly. But the most important thing is that we want to see schools taking appropriate steps to try to stop the violence. This is one of the most important points about the Clery Act, and something that I've started to talk about a lot more. Sometimes, as enforcement increases, there can become a total emphasis on the effort to comply. You will comply best when you simply go about the business of keeping people safe, and doing so in conformity with your campus safety and crime prevention program. So we do not intend to cite schools because we think a particular incident of crime between intimate partners was dating violence and the school called it domestic violence, or vice versa. Just do the best that you can. What we want to see is that you are giving that contextual information that I talked about to users of your crime data by properly classifying these incidents to the best of your ability. And then, as importantly, or more importantly really, doing something to intervene to make sure that people are not put back into dangerous cycles of violence within their relationships or within their homes.
And I think that's kind of one of the biggest takeaways that we had in reading the new handbook, is there's so much of a connection between what the institution is doing on an ongoing basis. So it's moving away from the concept, as we've seen institutions do, especially over the past few years, it's moving away from thinking of Clery as a thing that we do annually. We're putting together the report, we're doing Clery, and really looking at it more from the context of these are ongoing requirements, things that we're putting in place on a regular basis in order to support the members of our campus community. So I think that that was so well said. Some of the additional information on the slide, again, we won't read it out loud to you, but it's helpful for when you're going back and revisiting counting for dating violence, domestic violence, and stalking. is that there's also additional context for how to record stalking. So remember that it's at the first location that the perpetrator engaged in stalking or the victim first became aware of the stalking. And it's not necessary that all stalking activities occurred within Clery Act geography. So it's really going back to where was the location in which we know at least one of these behaviors, because stalking is a course of conduct, occurred, and would that be tied to our Clery geography? In just a moment, we're going to be able to get to kind of the bulk of the response around stalking, so the information that's captured in Chapter 8, which really goes into far more detail as opposed to just, okay, do we have this as a number, to what are we doing in these instances where, unfortunately, our community is affected by dating violence, domestic violence, and stalking. And historically, we know that for all of you, sadly, this is not new. These are not new crimes to impact your community. They were certainly impacting your community far before these amendments in 2013, but they weren't always necessarily reflected in your statistics in the same way. You know, you might have had an aggravated assault that was actually domestic violence. So hopefully what this is doing is giving your campus community a better understanding of the scope of how this type of violence is affecting the campus, and also giving you then avenues for prevention response that you might have not had before when the community didn't have such an understanding of these types of crimes. As a reminder, the hierarchy rule does not apply to VAWA offenses. And then as we look at the exception, one of the things that we put on the slide for arrests and referrals is the comparison between the language in 2011 versus 2016. So I think that is a very good summary of what we've already addressed, in that arrests and referrals do not fall underneath under the hierarchy. Now, I know we've received a couple of questions from folks who are looking ahead or processing incidents on their own campus, and they were asking questions about, for example, if a person is arrested for one type of law violation and referred for disciplinary action for a different type of law violation. We know that historically institutions in those scenarios would only count the arrest. That still stands. So there are going to be areas in which the institution is using that type of discretion in terms of what they are reflecting within their statistics. Another area that we see is if a person is both arrested and referred for disciplinary action for a single incident involving a law violation, you're counting only the arrest. So there is, in some sense, I hesitate to use the word hierarchy out of avoidance of confusion, but there is, in a sense, times in which an arrest will trump a referral. So I'd encourage you to go back to the examples that they provide in the handbook and the sections that are noted in your slides to revisit that for your own campus as you evaluate arrests and referrals. The other thing that we wanted to point out, which may not be relevant to every institution, but we know every single week at the Cleary Center, we were consistently getting questions about decriminalization of marijuana. So I really appreciated seeing in the handbook specific language, which there was some before around the decriminalization of marijuana, but it's certainly something that we've seen more and more frequently, you know, even past the prior release of the handbook in 2011. So there's specific language talking about if it was decriminalized within that state, it would not be counted as a drug abuse violation because it's not a violation of law. And for arrests and referrals, there needs to be a violation of law, not just policy, in order for it to be counted. And that also does count for a referral. So there's specific language speaking to not only would it not count for arrest, but it wouldn't count for referrals because, again, it's not a violation of law. Last but not least, for unfounded crimes, as Jim mentioned, we certainly wanted to make sure that we address that. There's a lot of really fantastic context on 351 to 354 in the handbook, so that's chapter 3, pages 51 to 54, about unfounding crimes to help give you additional information and understanding as to what should be or what would count as unfounded. So those are the incidents that are found through an investigation by foreign law enforcement to be false or baseless. So it would not be a situation in which a person decided not to move forward with a case. It's not a situation in which someone is uncooperative. There are a lot of really great examples that they provide as to what would not be unfounded to help clarify then what would count as unfounded under the Clery Act. So before I move on to collecting statistics and looking at, okay, where are we getting these numbers, who's sharing this information, are there any other things that you would note, Jim, before we move on to our CSAs?
Two really quick things. One, about the decriminalization of marijuana. Make sure that your state has actually decriminalized. There are various ways that states have gone about the process of legalizing or decriminalizing usually personal use weight marijuana. Some states, or at least some schools in some states, think that their state has decriminalized when what they have really done is changed the offense matrix about what the punishment will be. For instance, there are places where now instead of having to go before the judge, you're just issued a criminal summons and you pay your $25 and you go about your business. It's still a crime. Okay, so you just have to know what the actual rules in your jurisdiction are. One other thing, though, please remember that it is still illegal under the Federal Controlled Substances Act to have or use marijuana, certainly to sell it. So these exceptions to state law for accounting purposes under the Clery Act have nothing to do with what federal law requires. So for instance, do not, on your school campus, allow some administrators or health providers to say, bring your medical marijuana onto campus, we'll store it for you and dispense it. You cannot do that. That makes you a drug dealer. Okay, so you need to be very careful about that. And under another law that we enforce, the Drug-Free Schools and Communities Act, schools could really get themselves into a situation in terms of their federal funding if they start doing things around marijuana that are still prohibited under federal law. So you really have to keep it straight here about what is okay and what is not. One thing about the unfounding rule as well, understand what that language that Abby went over in the handbook is saying. It's saying where the evidence, where the available information, whatever it is, would lead a law enforcement officer to conclude that the report was false or baseless. It's not the other way around. It's not that the student comes in and says, I was the victim of a sexual assault, but it was someone I know, they didn't leave any bruises, I don't have any evidence, I don't agree to come back because you have a policy that says I have to come in the next day for a second interview, I'm not giving you my clothes for forensic testing, I'm not interested in testifying against anybody, I don't want to give you a witness list, right? All of these things. We go to school after school where schools try to say to us the reason why we didn't disclose this group of sexual assaults is they didn't comply with our reporting policy. None of that matters. If the person comes in and reports, that's a report under the Clery Act. Anytime information about a crime is brought to the attention of the institution, local police, or another CSA, it's in unless the evidence examined by a law enforcement officer shows that the report was false or baseless. Okay, thank you.
I want to move on to the next section, but I do want to highlight, because we had multiple people asking the same question, to see if you could add some additional context around this area of institutions where their state law does say that roommates would fall under domestic violence. I know there's some language in the handbook that speaks to that is not the intention. Is there any other clarification that you could give in that particular area?
That is one where I think we are going to have to issue some additional clarification, because we know some of you have the problem where the VAWA language, and this was something we talked about at the table during the negotiation, you see very few references in our definition to state law, except of course in the drug, alcohol, and weapons area, where it's the only place that you can go is to state law. But with the VAWA offenses, where you're supposed to want a national standard, the Justice Department and Congress in its wisdom talk about state rules. We are going to have to issue some clarification that makes clear that we are not interested in these roommate squabbles, because we don't think that those things are truly domestic in the sense that that term is normally used. Now, some of them become that. Some of them start that way. but that would be based on the relationship of the parties, not the mere fact that your Housing and Residential Life Office decided to put these two people together in a room. We don't think that constitutes a domestic situation. And we tried to clarify that in the handbook, but where you have those conflicts, what I would encourage you to do for now is simply document them and be able to say that we treated them consistently. We either followed the handbook for Clery purposes, or we decided to include more incidents because we think our state law required us to do so, until such time as we're able to put something out that gives you a little bit more contextual information about how to apply the VAWA rule.
I think that's really helpful. And you also addressed one of the other questions that had come in around, well, what if you have two individuals who are roommates, but then they also happen to be dating and then they're no longer dating? Would they still fall under? So I think it goes back, the core question or the core answer I think that you provided, which is really useful, is it's going to go back to what is the relationship between those two people. Great. So we're going to move on to collecting statistics. And again, the definition of campus security authority did not change at all, but there were some specific areas in which the department provided some additional examples that might be useful, as well as context for pastoral and professional counselors. So one of the things that we know is that pastoral and professional counselors are exempt from Clery reporting. What the handbook does is it breaks down what some examples of what that state licensing typically requires for those roles, so you can really break out who fits within that requirement. This ties into some of the new examples that we see for campus security authorities. The Title IX coordinator, which we certainly have had information based on that document that Alison referenced a little bit earlier from Westat in 2011 or 2012, providing context of the fact that the Title IX coordinator is a CSA. But we also see areas such as an ombudsperson, the director of a campus health or counseling center, victim advocates or others responsible for providing victims with advocacy services, and members of a sexual assault response team. So one, what the definition for pastoral and professional counselors and the context around it does is it provides an example of the difference between, for example, individuals who might have privilege within their state. As a former victim advocate myself, when I was functioning within that role, I did have confidentiality within my particular state because of a certain number of hours that I spent in training becoming an advocate. That would not, that my time as an advocate under the state would not have put me in this category of pastoral or professional counselor, because I didn't rise to the level of a pastoral or professional counselor in terms of the hours or the function. But this is the first time within the handbook, and I'm going to ask Jim to speak to it, that we've seen this specific connection to victim advocates, members of the sexual assault response team, director of the campus health or counseling center, so explicitly tied in our examples of campus security authority. So if you could just provide some context, since I know that that is a question that we've received frequently.
Yeah, we spent a lot of time on this, just figuring out how to present this information in a way that folks would better understand. A lot of this comes directly from enforcement cases where we have seen that some schools didn't understand the concept of the CSA. One of the easiest ways to say it, I think, is to understand that the law confers upon certain jobs the obligation of a CSA. A school doesn't designate CSAs, it has to identify them. Some schools still think, well, we can go through and decide who's in and out. That's not how you do it. The law decides who's in and out. You just have to do the right job of identifying those people and then hopefully training them and giving them some easy mechanism to provide information to people who can do things with it that need to happen, like classifying an incident correctly or evaluating if a timely warning is necessary. We don't expect the people on this list to actually be classifying crimes. In fact, if they try, they'll probably get it wrong, and it's asking too much of them. They just need to know they are CSAs and know how to get the information to the right people. And what you see here is that it's pretty much everybody but the faculty and the janitors. That's the way I say it sometimes. Now, you know, under responsible employees, under Title IX, there's additional people who are in the loop. We don't think that CSA needs to go that far. But when you look at this, When you look at that third prong in the regulation of who is a CSA, which is anybody with significant responsibilities for student and campus activities, you would easily be able to fit the people on this list into that definition. Now, the one that bothers some people is the director of a counseling center. But understand that a lot of times the director of a counseling center is not a counselor. They're an administrator. And so you need to keep that in mind. You need to be a little bit mechanical about this. We understand that there will be some difficulty for people who wear more than one hat, which at small schools is common. You could have somebody who 3 days a week is an advocate and 2 days a week is a counselor. I'll tell you what I would do. I'd make sure that there is some kind of advisory notice posted in those different offices or in the materials that are provided to persons who come in for services that says, when I'm on this side of the building, I'm a counselor. When I'm over there in the building next door, I'm an advocate. And here's what my responsibilities are under the Clery Act and other laws so that people who come for services know what to expect. One last thing about that is that we have a lot of schools, and I say this sometimes like about the pastoral element. We have schools where everybody's a priest or a rabbi, including the football coach. It's about the job, not the status. So if you're a football coach or a dean of student affairs, and you also happen to be a priest or a rabbi or a pastor of some kind, when you're in that job, you have to understand that the hat you wear is that of a CSA.
So it's really going back to the function. Now, one of the things that a lot of the questions that were coming in tied to, and you touched on this a little bit, is for the director of campus health or counseling center. I appreciated kind of that clarification that that person might not always be a counselor themselves. If they're in a supervisory role and those counselors do share this information with the director, would those incidents that are shared by the counselors be expected to then be reported by the director?
No.
Okay.
No. So, yeah, because if that student went to a counselor, a protected person here, a professor, a professional or pastoral counselor, and that's the only person they go to, then nothing goes anywhere. Or at least it doesn't have to unless the school has set up a voluntary confidential reporting system so that statistics flow in, although no personally identifying information would move. Just because they then tell their boss, that does not put the boss in the position of having to report anything.
Okay, that's very helpful. And then the other one that came up, we know that the Title IX coordinator is a campus security authority. So a couple of folks were wondering if they establish a campus process, because we do see this intersection between Clery and Title IX, campus security authorities, responsible employees for the purpose of Title IX. If they establish a campus process in which responsible employees that are also CSAs are expected to report to the Title IX coordinator, are they allowed to, as long as this is a part of the campus process, assume that that Title IX coordinator is responsible for sharing the information for the purposes of Clery? So essentially only establishing for any areas that do intersect with Title IX that the report goes to the Title IX coordinator, who will then make sure everything that they're communicating it with whoever they would need to on the campus for the purpose of Clery.
A school can always do that. You can set up those reporting lines internally, but that should be spelled out very clearly in some kind of an internal policy, at least, that could be shared with the department, say in the case of a program review or some kind of general compliance check. And then that Title IX coordinator needs to understand that the school, this isn't the Clery Act doing it, this is the school doing it by policy, saying, well, now you have these Clery Act obligations as well. And then that person would be on the hook. So some schools have legitimately decided that they don't want all of their young graduate assistant part-time coaches reporting directly to the police as CSAs because they just think it'll be unwieldy and it's too many people potentially coming at them. You say all of this is going to go to the athletic director. Well, that puts some pressure on the AD, but that's okay. We're fine with that as long as that AD understands that when that information flows to them, I now have responsibilities in terms of, one, disclosure, and two, getting this information in a timely way to somebody who can decide things that I probably don't understand, like, do we have to issue a timely warning?
Right. And so we only have about 10 more minutes, so we want to make sure that we're covering the rest of the content. So what we're going to do now is just work our way through the remainder of the content, and then certainly work in any questions as we can for the rest of the time. We appreciate all the questions that we've seen thus far. Some of the questions that were asked we're actually going to be able to acknowledge through the content, so we appreciate that. So one of the things to go back to, a key takeaway here, is as we look at that examples of CSAs, we know that that would include victim advocates, members of a sexual assault response team. And for the sexual assault response team, typically you have individuals who are campus security authorities as a part of that team already. So theoretically, the information should have already been shared, but there's certainly more information, or there's now more direct communication within the handbook that specifies that. You also want to really think about who the institution is directing individuals to report crimes to, because if you designate a particular individual or office as a place to whom to report, that is making them a CSA. Now, I know a lot of the questions that were coming in around advocates in particular were around this balance of, well, what about if in my state the institution or that individual has confidentiality? The thing that we would always go back to in this area, and you'll see this coming up in your slides as well, is that the Clery reporting is not tied to personally identifiable information. There might be times in which that information is shared, particularly if that person wants the information passed along. Before we get to the reminder of that, we also want to reiterate there's some helpful language in the handbook that's really talking about the role of CSAs. Again, it's tied to their function. They're responsible for reporting those crimes that were reported to them in their capacity as a CSA, but the examples that the department provides really helps to provide that distinction between their function within their CSA role, someone reporting to them, and the fact that they might go to, for example, a Take Back the Night event and hear people disclosing, and that is not going to be a report. So a lot of this is in line with previous guidance that we heard from the Office for Civil Rights in connection with responsible employees. And it's really looking to, we want CSAs to be sharing information that's reported to them. That does not mean that we are rushing to share any overheard conversation that we're hearing in the hallway. So you want to think about the CSAs within that role. Do they have an understanding that when someone comes to them that they are passing along this information? But you can look to page 4 or 5 for some of that additional context or guidance. But you are correct, though, that if somebody is a CSA and that information is being shared, that means the information is being evaluated from the experts on the campus as to, for example, whether or not it's a Clery crime, whether a timely warning would need to be issued, whether or not that information falls or would need to be recorded within the daily crime log. So all of those different steps are still taking place. So although those advocates are not sharing identifiable information, you'll see the language from the handbook that it's possible for a CSA to fulfill responsibilities while still maintaining victim confidentiality in most cases. There still would be the evaluation for timely warnings depending on the specifics of the case. So hopefully that provided some additional context. We know that you may have kind of more things that pop up for you. So again, at the end of the presentation, we'll make sure to provide additional contact information. And then lastly, in this particular section, we also highlighted some of the language related to requesting statistics from local law enforcement. The requirements didn't change in this area. The handbook is only reinforcing what is required under the regulations, under the statute. But what it does is it provides you some context for things to think about. So when we're making the request, are we providing specifics as to what information we need? Are we making sure that when law enforcement is providing us with materials and with content that we're receiving what we should be receiving? Any quick takeaways, Jim, before we move on to ongoing disclosures and then the magical Chapter 8?
Nope, that was perfect.
Okay, great. For the daily crime log, again, we're not talking, if you look in your notes, we didn't highlight anything particularly new, but what we appreciated about some of the language that you see there related to the fact that if the state has a state crime log and the daily crime log that they're implementing for Clery purposes, there's this recommendation or this suggestion that they could, that it might be useful to ensure that you're using UCR within your crime log, so that when statistics are being reported, when we're capturing them within our annual security report, that there's consistency between what we had in the daily crime log. It's really just an element that can really help you as an institution make sure that as you're going through these statistics, making sure that they're accurate, that you've already had steps in place in terms of managing the daily crime log and other elements that you take, so that it might not be or feel as burdensome when you're compiling the information. And then we also included some of the highlights or pieces that we thought were relevant or useful in relation to emergency response and evacuation. Again, nothing new. Just the reiteration that if you're going to have a multimodal approach, which is certainly encouraged, make sure that you're really clear about those communication methods, that you feel comfortable that individuals within your campus would receive that message if a crime is happening on your campus. And then for timely warnings, the reiteration that they are on a case-by-case basis. So you are going to consider the information that's available to you, for example, whether the alleged perpetrator was reported or apprehended. There are a number of different factors that you will be evaluating to determine whether or not an incident is a serious or ongoing threat to the campus community. A big takeaway from the handbook as a whole is, where is your documentation? Are you documenting all of the specific information when that report is disclosed? So do you have a document that specifies whether or not you chose to put out a timely warning for an incident? If you chose not to put out a timely warning, why, for example, did you choose not to issue that warning? What was the information that you received that caused you to believe that there was not a serious or ongoing threat to the campus community? But again, Jim, anything to reiterate there before we move on to Chapter 8?
Only one thing on the crime log. This is really important. Please make sure that you update your dispositions. And number two, although you can use state crime classifications, we would really encourage you for your Clery daily crime log, which is to be easily understandable and available to the public, to use something that syncs up with the definitions used under Clery. And please stay clear of jargon. Don't use code section numbers that wouldn't mean anything to someone in the public. And I would also encourage you to stay away from amorphous codes, which will do nothing but bring negative attention on the school. If you have major cases, I would not just enter them as administrative information or classified or something like that. The whole point of this is disclosure and transparency, and we want the log to reflect that.
Right. And then lastly, before we start wrapping it up, we wanted to make sure, and you will see it reiterated in the slide here, the biggest takeaway for Chapter 8 is to read Chapter 8. We didn't want to spend too much time on it in the webinar. One of the reasons for that is this is one of those areas where as you go through Chapter 8, you might say, this part doesn't feel as new to me. There's certainly additional helpful context, but one of the reasons you might feel that way is that a lot of the information is coming from the preamble to the final regulations. For the most recent amendments to Clery, there's additional context and things to think about that you should certainly take into consideration. But for most of your institutions, these are areas that you've been working on, policies that you've been diving into for quite some time now since we've received those final regulations. So in terms of going through it, we would recommend that you would review the slides that we included for this section. And again, our little code here was that anything in bold are some of the pieces that might be beneficial to pay attention to, some of which were included in the preamble, some of which weren't. Looking at when we're talking about our educational program, what do we truly mean by informed by research? We know that there's a lot of research out there related to prevention and awareness for sexual assault, domestic violence, dating violence, and stalking, but it also really highlights that there's more to learn. So if, for example, you are incorporating a promising practice, something that your institution has developed or that another institution has developed that's not yet a best practice, how are you evaluating, how are you making sure that you are incorporating this into the work that you do? In terms of training for individuals on the campus, it reiterated that it does not require mandatory training. We're making training available to all incoming students and new employees, and that means a good faith effort. So making sure that we are providing formats where people could easily participate, where they know that the training is occurring, that they can easily access the information. I'd encourage you, we have a number of free webinars that we already recorded since the regulations have been in place. We have one that Jim was kind enough to join us for in December of 2014 that's available for free on our YouTube page. So I'd encourage you to go back and revisit that webinar before or after you read the handbook, because it provides additional thoughts directly from Jim, directly from the Cleary Center, and suggestions as to how you might implement some of these areas. You might cover all of your training elements in one training, or they might be in different training, which is different segments, which is more likely for most institutions. So just consider that fact that it doesn't have to be one magical training that's covering all of the new requirements related to incoming students and new employees, and then our ongoing programs and campaigns for our campus community. We also really wanted to highlight that there are specific sections within the prevention requirements that call on you to incorporate the definition of sexual assault, domestic violence, dating violence, and stalking within your jurisdiction. Those jurisdictional definitions are strictly tied to prevention. They are not tied to how you're implementing your policy on the campus. That would be looking to your Clery definitions. So make sure that as you're communicating in relation to prevention, that you're very clear that those jurisdictional definitions are important for referencing if somebody's choosing to access the criminal justice process, and relevant. Definition of consent in the applicable jurisdiction. Again, all of this is really useful to students and employees if they would choose to move forward with the criminal justice process, but that is not the requirement for how you're implementing your policy or your conduct process. So being really clear about those distinctions and how you describe those in the annual security report will be important. And then they certainly reiterated that their definition for risk reduction might be very different from how you're thinking of risk reduction within your particular campus, or historically how the campus has looked at the phrase risk reduction. So we'd encourage you to look back to that definition and make sure that your programs are really comprehensive and not done with a tone of victim blaming, that it's really looking at primary prevention and how bystander intervention can be a tool. In addition to that, you'll notice as you go through some of the highlights that we reviewed, we also incorporated some of the specific areas for procedures that a victim should follow for sexual assault, domestic violence, dating violence, and stalking that have occurred. You'll see written information for students and employees as to rights and options that are available to them. But you will also see information specifically to victims of sexual assault, domestic violence, dating violence, and stalking about the rights and options, for example, how to preserve evidence, what resources are available, the fact that they have the option to notify law enforcement, that they also have the right to decline to notify law enforcement, the rights of victims and the institution's responsibilities related to no contact orders, who to contact, what that means in terms of how the institution implements, and who they would work with at the institution or who they should reach out to in relation to a no contact order. There's also specific information related to confidentiality. So recognizing that that particular statement is talking about information in publicly available record keeping. So when a person discloses, even if their personally identifiable information is shared within the institution, that is not going to be shared within a timely warning, emergency notification, that's not going to be shared within the ASR or the daily crime log. So you want to think about how and where you're including that language within your policy, within your annual security report policy statement. And then you also want to talk about who is the person that determines how confidentiality comes into play when a student is requesting accommodations or protective measures. So there may be times in which their identifiable information needs to be shared with certain individuals. And so you want to be very clear within your policy and within your policy statement who is responsible for that particular role, and who would be working with the student to implement those particular areas. So even though you might not be able to fully protect confidentiality as a campus, there might be others at the institution that need to know some information, you are still taking steps to protect their privacy, and that there's a specific person who's weighing those factors. There's also some really helpful factors that are provided for requests for accommodation. We know that both students and employees have the option for change in academic, living, transportation, and working as applicable if they're requested and reasonably available within the campus community. So those factors really help you walk through how do we anticipate or determine what type of request is reasonable, what will that look like on our particular campus. And then there's also some useful context in relation to the procedures. How do we implement our institutional disciplinary process? I will say that for our organization, this is a gap that we've seen in working with institutions, especially if they work with the new regulations, is that a lot of times there's missing information, particularly in relation to employees. So since we know the requirements are really asking us to communicate within our policies and our policy statements, those cliff notes within the annual security report, as to what our disciplinary procedures are, communicating timelines, who's involved, and the different steps and sanctions and standard of evidence, and a lot of other specific information. You really want to take the time as an institution, and we know that many of you are doing this already, to make sure that all of the different required elements of these requirements are incorporated into your policy and into your policy statement. And Chapter 8 really walks you through, okay, what do we need to have and how can we implement it? So, you know, we had somebody at a training last week say, you know, we would create a book club just around Chapter 8, and we would heartily agree with that. There's a lot that institutions can take away. So pay attention to some of the bolded areas. Again, many of the areas that we're highlighting here were within the final regulations or the preamble to the final regulations. So if that's something that you're revisiting, I would dive right back into some of those past webinars. And we're also designing some webinars for National Campus Safety Awareness Month, in which institutions are able to submit questions in advance. And one of those webinars is focused on sexual assault, domestic violence, dating violence, and stalking. So for any of the questions that we're unable to get to within this time frame, I'd encourage you to sign up for one of those webinars, submit your questions so we know where to spend our time and our attention as we pursue this further. Okay. Last but not least, the other area that we would highlight for this is that there is some additional context provided to the rationale, since institutions have to provide the information about the results to both the complainant and respondent, or accuser and accused, as is used in Clery. This provides you context as to what information should be included, what type of context should we be providing to these individuals, and how do we make sure that we're getting it to them. So I know, Jim, we're running over our time, but I do want to make sure if there's anything else that you wanted to add to that piece that we have a chance to do so.
Just very quickly, because I think that was an excellent summary of the requirements. For instance, with the very last point that Abby covered about giving a rationale for a decision, the reason for that change is because many institutions over years would simply say to complainants, well, we didn't think you had enough evidence, right? You lose. It needs to be a substantive rationale, because the point is that that information could be used for appeals purposes. Perhaps somebody didn't make a point clearly enough, or show specifically enough how somebody violated the school's codes of conduct. I think with the whole presentation that Abby went over, especially in the VAWA context, shows is that the department has always felt that the Clery Act is a campus safety, crime prevention, and student and employee protection law. But if there was ever any mistake that consumer information law, I think VAWA makes it clear. People have substantive and procedural rights under the Clery Act now that are independent of other laws like Title IX of the Civil Rights Act, or Title VI, or any of the other laws out there meant to protect people. So schools need to not think of these things as just a litany of paper policies that they need to create, but rather programs and systems that support students and help to keep them safe.
And that's the perfect lead into this last section, which is around publishing the annual security report, because that's something that we frequently say around this document. We know that the annual security report is something that you share with current students and employees and prospective students and employees. You share that information by October 1st of each year. But the annual security report is not only a document that you create to be helpful to your campus community, but it's also an institutional practice to make sure that you're going through and ensuring that you have policies on your campus in a number of different campus safety and security areas that are guided by the Clery Act, and that you're evaluating on an annual basis as to whether the structures that you've put in place are working. So not only are they compliant, but are they also really serving this purpose, which is how do we best protect and support our campus community. And so look at the annual security report as an opportunity to practice that. There are a couple of things that we highlighted from the handbook in relation to the ASR. One, again, was in the final regulations, but just an acknowledgement that there was some additional content in relation to law enforcement authority and the jurisdiction of security personnel that was included within the amendments to Clery. So look at your statements related to law enforcement authority and whether or not you're addressing the jurisdiction within that area. There's also a policy statement related to accurate and prompt reporting, and a lot of institutions are missing this piece, again, because it's new, it's relatively new because of the recent amendments. But the phrase of when the victim of a crime elects to or is unable to make such a report. So that doesn't mean that a victim chose not to report, but you decided that's in their best interest, and so you're going to share it anyway. It's really looking at, especially if we're highlighting bystander intervention on a campus, how are we communicating when we're talking about reporting that we want everyone in our community to feel empowered to report if they see something happening within their community that they're concerned about or that they think that somebody is unsafe. So say for that person is unable to report because they're incapacitated, that is what this language is really intended to speak to and to really build a culture in which people are coming forward with that information. There's also still the requirement, again, not new, that the institution has a process for disclosure to the alleged victim of a crime of violence or non-forcible sex offense or the next of kin. So again, a process that your institution currently has, but just to note that it may come across a little bit confusing because it's still referencing non-forcible sex offense. Recognize that that references incest or statutory rape when we're making that analysis. And that disclosure is something that you're doing as a part of the requirements for the Violence Against Women Act, or at least in relation to sex offenses. So again, you should already have a process in place for those particular pieces. For presenting statistics, one thing to highlight, a question that was coming in a lot, is when should we be implementing this guidance that we've received from, or additional information that we've received from the department? So Jim may have more to add or expand, but one of the things that we've been communicating to institutions is that you have not yet published your 2015 statistics. We know that you're in the process of delving through those now, putting together the annual security report. So you would want to make these considerations for your 2015 statistics. Is there anything that you would kind of add or want to expand on for that, Jim?
No, I think that is exactly what we're looking for.
Okay, great. And then you're going to present all the statistics other than those for hate crimes and unfounded crimes in a tabular format, so in a table, as many of you, or as I know you've already been doing. You still have the option, as you have before, to present the hate crime data in a narrative as opposed to a table if you think that that's helpful to your campus community, and they have some examples in the handbook on the page that's indicated as to where you can find that. And you can present statistics for unfounded crimes in either a tabular format or narrative or descriptive format. So we know that we've now added this category where institutions are reflecting unfounded crimes within their statistic. So what this is saying to you is, one, you're not required to break down the number of unfounded crimes by geographic category or type of crime. I know some institutions were choosing to do that. But it is saying that you are really only asked to do a bucket, so to speak, of the unfounded crimes. Now that said, Jim, if an institution decided to break it down for additional context, would that be something that they might choose to do, or is the expectation that it will be one category of those numbers?
No, a school would be free to add additional context on that topic if they thought it was helpful.
Okay. Okay.
So they could list it crime by crime.
Great, and I know a lot of institutions were already doing that because they think that that provides some good contextual information. So something to think about in terms of classifying or reflecting those unfounded crimes. And then we'd also point you to, because we know that you're changing and updating policies and procedures throughout the year, so we point you to this page 910, 911 within the annual security report section that talks about if you make these changes, because we know you're always looking to improve your processes on your campus, how you can reflect them. So updating your annual security report, communicating that to your campus community, and how to do so. So we would point to that for those of you who may now be in the process of updating policies or will be doing so in the future, even after an annual security report is distributed. So our biggest takeaway, and we appreciate those of you who have stayed with us on the line, as we know that we ran a little bit over, but wanted to make sure that you have this information, is to document, document, document. How are you maintaining records as to who is reporting, what report has come in, and the actions of the institution? Are you keeping that information for 7 years? And again, big takeaways are there's a lot of great examples and language reflecting different examples that it might be relevant to your specific institution. So we encourage you to read the handbook. We encourage you to use these slides as a reference as you're trying to hone in on specific areas of relevance for you. And we know that this is one of the first times where we saw language within the handbook talking about how it's intended for use from program reviewers. So what I really appreciate about that is that it's the department really saying, we're creating this document because we want it to be helpful for you and that it's going to be helpful for us in really determining why you made the decisions that you did. Any final points or any language that you wanted to share, Jim, just based on the conversation that we've had today?
Only to say thank you both to the Cleary Center and to all the participants today. I think it's great that opportunities like this are made available for people to learn from people who have really dedicated themselves to learning this information and being good partners both to the agency and to the community. And I also want to thank the participants today for all they do in service to students and employees on all the campuses around the country. So thank you.
Thank you. And we just want to echo that as well. We know that you are spending a lot of time making sure that you're doing right, not just by this federal law, but by the students and employees on your campus. And we as an organization are always here to help and support with that. We have a list of a number of the different programs that are available. Members of our collaborative program, we are really fortunate to be able to work with members of our program, which is a learning membership program in which campuses really do a deep dive into all these different areas that we've talked about, and they build a multidisciplinary team in order to do so. But we've been working with campuses doing annual security report reviews. They've been doing their own self-assessment, and we've really been inspired by our members and certainly by the people who have attended our trainings in their level of commitment to doing this right. So your participation in this webinar is just another indication of that, and we appreciate that. We'll also point you, I know that my colleague Megan was plugging in some of these links as we were talking about them, so thank you, Megan, for that, to some of the other learning resources that we have. For National Campus Safety Awareness Month, we have a number of free webinars and resources that will be available to anyone who chooses to sign up for the month. And 4 of those webinars, we'll have more than just the 4, but 4 of them are focused specifically on Clery compliance and some of the frequently asked questions that we are receiving. As part of those webinars, you are able to submit questions in advance so that we can be sure to incorporate them into the content. So not just while you're participating and typing, but that we can be taking them into consideration prior to the webinars. So we'd encourage you to sign up for National Campus Safety Awareness Month and to access some of those resources for free. They will expand on a lot of the things that we've talked about today. We also have Clery Act training seminars. We've been readily moving to update the content, so all of our in-person trainings are now up to date to align with the handbook, and certainly our instructors, which come from not only the Clery Center, but from institutions across the country, have also spent a lot of time and dedication making sure they fully understand the most recent guidance and information and can share it with you. So that schedule is, our current schedule is online, and we will be releasing the 2017 schedule any day now. And we're also in the process of updating our CC, our accounting guides, our many different resources that are available through the store on our website. So please, if those are the types of things that are useful to you, if you're looking at how do we better connect with our campus community and with the professionals who are doing this work and give them some practical tools, there are things on our website that might be a good fit for you. Last but not least, we want to thank you for taking the time to join us today. We are recording this webinar, so we will be sure to provide you with that recording in case you are interested or you certainly want to revisit, because we know we covered a lot of content in a short period of time. We also plugged in an evaluation within your panel, so we really encourage you. We hope that you will click on that link and give us some feedback for what information did you really appreciate in this webinar, what information are you looking for more of. We know that the handbook was just released, so there are a lot of questions still coming in, and we will certainly be developing additional resources and creating webinars that we can share with all of you in order to best support the work that you're doing. We appreciate all of the efforts that we've seen from colleges and universities, not just after the release of this handbook, but throughout the year. So as a result, thank you so much for joining us. We will send you that email with a link to the recording and with additional contact information as is listed on the slide. So thank you again for joining us, and we hope that you all have a great afternoon.